All right, let's address the elephant in the room, or should I say the fraud squad in the courtroom. Being accused of financial crimes is no joke. It's like stubbing your toe, except instead of your toe throbbing, it's your entire life. But before you start panicking and shredding documents, take a deep breath. Seriously, inhale, exhale. Remember those overly dramatic legal dramas you binge watch? Well, real life legal battles are nothing like that, thankfully. No surprise witnesses, no last minute confessions, and definitely no dramatic monologues. They're far less glamorous, significantly less shouty, and involve a lot more paperwork. Imagine a mountain of documents that you have to climb, but without the cool mountain gear. This video is your crash course, your cheat sheet, your get out of jail, potentially free card. Okay, not really, but you get the point. We're here to help you understand the basics. We're diving deep into the world of the v fraud and corruption defense, arming you with the knowledge you need to navigate this legal labyrinth. Think of it as your personal guide through the maze of legal jargon and procedures. We'll break down the legal terms, explain the procedures, and give you tips on how to handle the stress. Because let's face it, dealing with a fraud case is stressful, but with the right knowledge and preparation, you can face it head on. So grab a notepad, maybe a cup of coffee, and let's get started on this journey together. Let's break down the ABCs of financial wrongdoings, shall we? We've got your classic bribery, where a little under-the-table exchange takes place. Embezzlement, the art of making company funds disappear faster than a politician's promise. Money laundering, because even dirty money wants a spa day. Forgery, for those who believe imitation is not just the sincerest form of flattery but a lucrative career path. And of course, corporate fraud, where suits play fast and loose with company finances. These charges aren't your parking tickets, folks. We're talking hefty fines, jail time that'll make you miss your favorite barista, and a social life that's drier than a popcorn fart. But hey, knowledge is power, and knowing your enemy, in this case the charges against you, is half the battle. Now, let's talk strategy. Because even in the face of accusations, you've got options. It's crucial to understand that the legal system, despite its flaws, offers multiple avenues to defend yourself. First up, lack of intent, a classic. This defense hinges on the idea that you didn't mean to commit the crime. It's like accidentally tripping and spilling your drink on someone, except instead of a drink, it's millions of dollars. Imagine a scenario where a businessman makes an honest mistake, leading to financial chaos. The key here is to show that there was no malicious intent behind the actions. Then there's the insufficient or unreliable evidence defense, where you basically point out that the prosecution's case is shakier than a Jenga tower built by a toddler. This involves scrutinizing every piece of evidence presented, highlighting inconsistencies, and questioning the credibility of witnesses. Don't forget entrapment or coercion, where you argue you were lured into this mess like a moth to a porch light. This defense is about showing that you were pressured or tricked into committing a crime by someone in authority or by circumstances beyond your control. And let's not forget the lack of proper procedure defense, because even legal eagles have to follow the rules. If the authorities didn't follow the correct legal procedures during your arrest or investigation, this can be a strong point in your favor. Finally, there's mistaken identity or false accusation, because sometimes life imitates a sitcom and you're just in the wrong place at the wrong time. This defense focuses on proving that you were misidentified or wrongly accused, often requiring alibis, witness testimonies, and sometimes even forensic evidence to clear your name. Chapter 3, Financial Forensics, Following the Money and the Mistakes. Time to roll up our sleeves and delve into the nitty-gritty financial records. We're talking scrutinizing those spreadsheets like your life depends on it, because it might. Were there any accounting errors that even a five-year-old could spot? Any unclear authorizations that scream red flag? Any misinterpretations that make you question if someone failed basic accounting? And let's not forget about those witnesses. Cross-examining them is an art form, like a delicate dance where you gracefully expose their inconsistencies, biases, and any potential benefits they might be reaping for testifying. Remember, in the courtroom, everyone has a motive. Chapter 4, Plea Bargains and Case Dismissals, Aiming for the Best Case Scenario. Let's be realistic, sometimes the best offense is a good defense, or in this case, a strategic negotiation. In the legal world, knowing when to negotiate can be just as crucial as knowing when to fight. It's about playing your cards right and understanding the nuances of the law. Plea bargains aren't about admitting defeat, they're about damage control. They can be a lifeline, a way to mitigate the potential fallout of a trial. It's a calculated move, often made to avoid the uncertainty of a jury's decision. Think of it as haggling at a flea market, except instead of a dusty lamp, it's your future. Every detail matters, every concession counts. It's a delicate dance where both sides give and take, aiming to reach a middle ground that serves their interests. Highlight those weaknesses in the prosecution's case. Offer up some cooperation, within legal limits of course, and point out any procedural missteps with the enthusiasm of a kid finding candy. It's about leveraging every advantage you have, no matter how small it may seem. And then there's the holy grail case dismissal. It's the ultimate goal, the dream scenario where all charges are dropped and you walk away unscathed. It's rare, it's beautiful, and it's like winning the lottery without buying a ticket. Achieving a case dismissal requires a perfect storm of favorable evidence, legal acumen, and sometimes a bit of luck. If the evidence is truly on your side, push for it like your life depends on it, because, well, it might. Every piece of evidence, every witness testimony, every legal precedent can be the key to unlocking your freedom. So, aim high, strategize well, and always keep the best case scenario in your sights. Chapter 5, Defense Lawyer Don'ts, Avoiding Legal Landmines. Now, a word of caution, even with the best defense strategy, there are some mistakes that can make or break your case. Ignoring financial forensic analysis is like going to a gunfight with a butter knife. Not recommended. Failing to cross-examine key witnesses. It's like ordering a pizza and not checking for pineapple. You're setting yourself up for disappointment. And never ever underestimate the power of challenging procedural errors. Remember, the justice system is like a game and you need to play by the rules, especially if the other side isn't. Lastly, never ever show up unprepared for complex financial arguments. Knowledge is power, and in this case, it might just be a ticket to freedom. Outro, case dismissed. Well, maybe. So there you have it. Your crash course in defending against fraud and corruption charges. Remember, this video is for informational purposes only, not legal advice. It's like trying to learn surgery from watching Grey's Anatomy. entertaining but potentially disastrous in practice. Did you find this video helpful? Subscribe